Hi, so I'm Professor Zubair Jahangir, and today I'll be teaching you all the very important regulations, that is your NCS regulations 2021. Now let's understand what is this NCS non-convertible securities regulations that have been introduced by SEBI. So this regulation is actually a merger of the existing two regulations which have now been repealed. So there were two regulations, that was the ILDS regulations and there was a non-convertible redeemable preference share regulations, which both have now been replaced. They have been repealed. And replacing that, we have a new regulations, that is the SEBI Issue and Listing of Non-Convertible Securities Regulations 2021. Now expect around 15 marks, that is 2 to 3 questions minimum from here. I'm going to cover this entire regulation in a short span where you get a complete understanding and covering every topic which can come in your exams. So two regulations, that is your debt securities regulations and your non-convertible redeemable preference shares, both of them have been merged. And what is the purpose of the merger? Okay, why these regulations have been merged and why do we have this new regulation? Now, if you read the definition, what was given in this debt securities, it said that the debt securities mainly covered your non-convertible debt securities. Now, when I say non-convertible debt security, means non-convertible debentures. And this was about preference shares. Now, these preference shares are also non-convertible. So, non-convertible preference shares. So if you see what the government did, what did SEBI do, that these non-convertible debentures and non-convertible preference shares, they have merged these two regulations and now called a regulation as non-convertible securities. And obviously this will cover debentures as well as preference shares which are not convertible. So with the merger, what happened is the government brought in reduced the number of regulations, the multiple circular in each of those regulations, the guidelines, regulations, all have been merged and now we have one simple regulation. Now, this regulation is very important from a CS company secretary standpoint also, because a separate recognition has been given to CS. So if you read section regulation number 27 sub-regulation 4, it says that when a company is getting listed and the merchant banker is listing the company, they have to mention who is their compliance officer, and the compliance officer has to be a company secretary only. So with these regulations, the CS have got a specific recognition where they say that they will be the compliance officer. Now these regulations, as we see in summary, what do? The non-convertible securities, which I'm talking of, non-convertible debentures and non-convertible preference shares, okay, which are pure which are instruments which do not be converted into equity shares. The listing of these securities, the issue and listing of these securities is covered. Issue and listing. So why does the company issue these securities? Obviously non-convertible debentures can be issued to raise funds, and with that money they can use for the business purpose and then get listed on the debt segment of NSE BSE. Now these regulations were amended in 2023 via the SEBI Issue and Listing of NCS Regulations Amendment Act 2023. The key changes in this Amendment Act were few. All the important ones I will tell you. First, they expanded the definition of green debt securities. Now this is extremely important to understand. Extremely important. Why? Because this is a specific security issued under this regulations. Let's understand. Now when I talk about debt securities, so debt securities is issuing debentures. Okay, non-convertible debentures. In this regulation, any security that we are going to talk is going to be non-convertible. So non-convertible debentures are being issued. But why are they being issued? For a green purpose, for a purpose which has been mentioned here. So green debt security is a debentures issued, non-convertible debentures issued for the purpose specified below. Now when I say green, why? Because it will be helping the environment, whether it could be pollution, raising funds to install pollution prevention and taking measures, or using eco-friendly products. They also talk about two interesting kind of bonds here. One is a blue bond. What is a blue bond? Blue bond is for water. So for making sustainable water management. So if I am raising funds for water management, water purification, then I will issue blue bonds. Yellow bonds, yellow is for the sun. So your yellow bond means you are using the funds that you will raise by issuing yellow bonds for solar energy. Then you also have transition bonds. So transition bonds are basically bonds issued by companies to transit to a renewable source of energy. So currently you could be having certain processes which pollute the environment. You would require funds to transit into a green source of energy. So for that also you can raise funds. So under these regulations, the green debt securities are very important, and in the 2023 amendment they added all these points which I just read out. The other important point here is when we are issuing debentures, so you will have to recollect that it is all about debentures, and as we saw in a Companies Act section 71, okay, spoke about debentures, right? Now here also we are issuing debentures, only thing is these are non-convertible debentures. So the provisions will remain the same, the debenture trustee, the debenture holders, the debenture trust deed, the security, everything will be the same in these regulations. Now one extra point that they have added, which is very good for the debenture holders. What they have said that if there is a default in repayment of the interest, there's two consecutive defaults in the payment of interest, or default in creation of the security, or default in redemption, then the trustees will get a power to appoint a nominee director. So appointment of nominee director is a new part that they have added. So let me explain in simple words. If the company has defaulted in payment of interest, creation of security, or redemption of the debentures, the debenture trustees will get an extra power to appoint a director at the board called as a nominee director who will look after their interests. Then in 2023 amendment, the period of subscription, when we are raising from public, the period of subscription they have given will be 3 to 10 days, which we will see when we are doing the detailed regulations. I have just told you what were the amendments. Now another part that they have added is something called as online bond platform. What is an online bond platform? Let's understand. So we will get into the regulations. Right now we are just taking an overview. The online bond platform, very simple. So when I want to buy shares, which app do you use to buy shares? Can you tell me? Obviously you might either be using Zerodha, or you might be using some other kind of app to buy these debentures, right? To buy shares. Zerodha, Grow, ICICI Securities, HDFC Securities, these are all your trading apps. Similarly, if you want to buy bonds, green bond, blue bonds, you don't have that provision. So there are these specific intermediaries. The platform is provided called as online bond platform, where on that platform I will download the app and purchase these bonds, sell these bonds. Now these online bond platforms have to be registered as a stockbroker to provide this facility. Okay, so very important, they have to be registered as a stockbroker So this is the amendment that online bond platform which provides you a platform to buy and sell bonds, these platform providers will have to be registered as stockbrokers, because ultimately even Zerodha and all of them are stockbrokers. They get those license. Similarly, even they will have to get, because they are facilitating, allowing buying and selling. So what are online bond platforms? These are platforms where bonds are bought and sold. They are actually these fintech companies, and they have to get a stockbroking license. This is the amendment. Now, coming back and going detail into the regulations. So if I will ask you, from all that I have spoken, what are these regulations about? Can you tell me in simple words? What are these regulations about? Can you tell me in simple words? So yes, the simple words are: non-convertible securities are issued and listed under these regulations. Again, I repeat, non-convertible securities, 1, are issued and listed under these regulations. Now, your next question will be, what do you mean by non-convertible securities? So I will say, okay, wait, come here. What do you mean by non-convertible securities? This is it. So the scope or the securities that are covered, or what you define as non-convertible securities, are this. So let's see, and all of this you will know except a few. So let's see. First, non-convertible securities means debentures, debt instruments, preference shares, right? So this, so you always know. When you go to read the definition of debt securities under these regulations, you will come to know that these debt securities are whenever they use the word debt securities here, they are talking about non-convertible debentures. Concept clear? Yes. Then again, your non-convertible preference shares. So again, redeemable preference shares. So these are non-convertible preference shares. Till here, absolutely clear? Yes. We know what are non-convertible debentures. We know what are non-convertible preference shares. These can be issued and listed on the stock market under these regulations. Simple. If you know, I've understood this much, go ahead and like it. Like the video. Further, what you don't know, there are some other kind of things which you must have never heard before, which is called as your perpetual non-cumulative preference shares and your perpetual debt instruments. Now, both, what do you mean by perpetual debentures and perpetual preference shares? Pay attention, okay? So, perpetual debentures and perpetual preference shares can also be issued. Now, I'll tell you what is the characteristics of this, features of this perpetual. What is it? So from the name itself, what do you mean by perpetual? Forever. So the investor will forever get interest on these debentures, or preference dividend will forever get preference dividend on these instruments. However, the company will have a right that any time, whenever the company wants, they can redeem them. So it is not going to have an exact date of maturity. Like in both this, in here, both of them, there is a fixed maturity date. There is a fixed maturity. Yes or no? 5-year debentures, 7-year debentures, 10 years preference shares, all of that. Here there are no time limit. The company gets an option to redeem whenever they know, whenever they want, after giving proper notice to the investors. These bonds, you must have not heard of them because these are issued under the RBI guidelines. So even when you go to read the definition of these two, you will see that it says as specified by RBI under its guidelines. So we will be seeing debt, preference, perpetual preference, perpetual debt. Okay, so as specified by SEBI. Moving forward, understanding the legislative framework of this regulation. When I say legislative framework means what? The entire regulation. There are 59 regulations here, all, and there are only 8 chapters. So let's see what are they and understand, okay, quickly. First, they give you the general conditions, that is from regulation number 4 to regulation number 24 talks about general conditions. Now this is very important because the general conditions can be written in everyone. It is applicable to all. Any issue or listing of these regulations, the general conditions are there. So if you learn them, it will help you to build your answer. Second, then they talk about public issue and listing of debt securities and preference shares. So public issue. So here we are making a public issue. Then is it necessary that a public company has to make a public issue only, or they can also make private placement? So obviously a listed company can make public issues also and they can make private placements also. So here when a private placement can also be done of debt securities and preference shares, non-convertible redeemable preference shares, right? So here we are talking of public issue and here we are talking about private placement. So chapter 3, chapter 4 talks about this. Okay, both of them of debentures and preference shares. Now, what is chapter number 5? Chapter number 5 talks about perpetual. Okay. These are issued under the RBI guidelines. They will perpetually give you interest or dividend, preference dividend, and company at any point of time after giving the notice can redeem them. So no fixed date. In 3 and 4 chapter there is a fixed date. Clear? Perpetual instrument of debt or preference shares, right? Now, interestingly, which I haven't told you now, is about listing of commercial papers. Is also covered under these regulations in chapter number 6. Chapter number 6 talks about listing of commercial paper. What are commercial papers? So commercial papers are issued by good credit rated companies. So let's say Tata's can issue commercial paper, Reliance Industries can issue commercial paper. Any company which is having a good credit rating can issue these commercial papers for short term needs. So the characteristics or the main feature of a commercial paper is it is a short term instrument up to 1 year. So short term needs, a good credit rated company can raise commercial paper. These are in the form of promissory notes where the company tells them, don't worry, we promise to repay you the amount. Chapter number 6 of these regulations also says that you can get these commercial papers listed out here and the procedure has been given. Then they talk about chapter number 6A, which has been introduced in 2023, about online bond platform. Now what is the online bond platform? If you want to buy and sell in bonds, there are some platform providers who give you the platform to trade. They mandatorily have to get a stock broking license, is what they have written here. Then they give you the penal provisions and the miscellaneous part. So I have covered the entire regulation for you, an overview. Okay. Now let's get into the direct regulation. First, what is very, very important is you need to know the definition of green debt security. So this is extremely important. Green debt securities, from the name itself you can decode it. These are debentures. Since it is an NCS regulation, these will be non-convertible debentures which are issued for green purpose. Green purpose means what? Sustainable energy. You can write about your water is blue bonds, solar is yellow bonds, for all these purposes, for making clean transportation of public, then climate change adaptation, management of waste, then ensuring that there is proper biodiversity. Biodiversity means many animals, insects, plants get extinct. So we need to do something to ensure that they don't get extinct. So that requires funds. So to ensure that there is biodiversity conservation, you can raise funds for sustainable use of forest, agriculture, etc. So all of this, afforestation. Deforestation means to cut down forest. Afforestation means to plant more trees. And that's why it is called as green debt security. It's very important. It has a good chance of coming in your exam. Okay. Now, let's get directly into the regulations and understand what all it is covering. Okay. Now, we are doing chapter number 2. Chapter number 2 talks about the general conditions. Now, understand the general conditions is about what? It is about listing and issue of non-convertible securities. So what will be the general conditions? See, I want you to apply your mind, your logic, so that you understand these general conditions. I'm not going to make you mug, I'm just going to make you think. If you have done your ICDR regulation, this will be a cakewalk, because in ICDR regulation it actually talks about how do you get yourself listed. Okay, so let's see. First, what all will be there in the general conditions? Who are eligible? So eligible issuers means the promoter should not be debarred. Okay, they should not be willful defaulters. They shouldn't be fugitive economic offenders. Okay, so all this negative list has been given, that if a company wants to issue NCS, none of its promoters, directors should be debarred or willful defaulters or fugitive offenders. Common sense. Next talks about in principle approval. What does in principle approval mean? In principle approval means for listing of NCS. Sorry. So let me explain. If I am going to list them on a stock exchange, I have to take approval of the stock exchange that listen, I'm issuing this money and I will get listed. I will list them on your stock exchange. So approval has to be taken. The general condition, yes. Then will come your SEBI intermediaries, because see, you're issuing and listing, so you have to appoint a lot of SEBI intermediaries, like your depository, NSDL, CDSL, your debenture trustee. Since you're issuing debentures, you will have to appoint a debenture trustee who will look after the interest of debenture holders. You will appoint the share transfer agents, registrar to the issue. So when you are issuing, having those centers, taking the application, doing the refund process, allotment process, you have a registrar to the issue. Getting a proper credit rating is mandatory, so you'll have to hire a credit rating agency. Then all the electronic issuance will be done through online, mode, through the depository. Then they talk about the day count, very very important, and they have put in the general conditions. Very simple. Okay, let's understand. Day count convention comes in case of debt securities, come in the case of debt or fixed payment securities. Let's understand. Okay, pay attention, market is important. Now if I have to give interest, I have to give interest on debentures. I have to give interest on debentures. In the month of January, I will get more interest, or in the month of Feb. Now, obviously, to do the calculation, you will do the principal. Let's say it is 1 lakh into 12% into 31 upon 365. Yes or no? If you do this, and here you will do 28 divided by 365, because February has only 28 days. So what is this? You are seeing the exact number of days, and it will happen that in the different months you will get different dividend or different interest, because the calculation is taking the actual number of days. Someone could also do this calculation by 1 divided by 12. Then in every month it will be same. 1 divided by 12, or some do they take this 30 divided by 360. This rule is also there. So in India we don't take this rule of 1 divided by 12 or 30 divided by 360. We take the actual number of days and actual number of days or months. So here also we won't take 360. Here also we won't take 330 by standard. We will take the actual days and we will take the actual year also, number of days in the year. So if it is a leap year, we will put 366. So very simple. Now you've understood the concept. In day count convention, India uses the actual method, and it is mainly to calculate the number of days and the amount of interest between two coupon periods. The 360 convention is the simplest method, assumes each month has 30 days and 360 and accordingly you have 360. We don't follow the 360 model. We follow the actual model as a day count convention to compute the interest or the preference dividend. Clear? Now, remember I told you that when we are issuing preference perpetual, the issuer keeps a right to call the redemption. They can give a notice and do the redemption. Similarly, here also it's something like that, right to recall or redeem prior to maturity. Prior to maturity. What does this mean when I read this sentence? That means the issuer can say that, listen, it's a 5-year time period. I am going to do a premature redemption. So this is a premature redemption. I'm going to pay the entire money to you in 4 years only. So it is foreclosing much early. So it's allowed. So here, this is the right of the issuer. If he wants, he can do a premature redemption called as a call option. He will say, listen, give back. He'll call and all his securities. He'll pay the money, the redemption amount, and release his securities. Put option is when the company can also give a right to the investor that, listen, I have a call option. I'm giving you also a right. If at any time there are some cases that they might decide that if this happens, you can ask for prior redemption. So the issuer can provide a right to the investors where the investors can ask for a prior redemption. Okay. Whatever will depend on the terms of the issue. Then coming to, since these are debentures, you will also have to maintain a debenture redemption reserve as specified under section 71. See, ultimately we are issuing two securities only, right? Debentures and preference shares. Now when it is debentures, whenever we're reading about debentures, you will see about DRR, you will see about debenture trust deed, you will see about debenture trustee, etc. Okay, so these are common. You can write it down. Then comes every security that is issued will have a separate ISIN number. Now what is the ISIN number? Every security gets, like as every person has a PAN card, every security also has a specific number. So when we are issuing any securities here, they should have that specific number. It is a unique identifier of a security. It is a 12-character alphanumeric number. It is assigned by the National Numbering Agency that are registered with the Indian Organization for Standardization. So you don't need to know so much. Just remember that they will have a ISIN number. For example, here I have taken the ISIN number. It also has a decoding method where the few will be called as the country code, the type of security. So for the company, they will have this ISIN number, and the last, the 2 digits here will give you a specific number to the security. So I can identify that it is a India, E has a separate name for the company, etc. So every security, when you go on the stock market website also, you will see the Tata Steel or any other company will have a separate ISIN number. If you bought any shares, you will come to know the number as well. Then since it is a, you are issuing debentures, they will also talk about trust deed, that you will have to issue a trust, enter a trust deed, has to be made, it has to be entered with the debenture trustee. It will be all the details of the trustees and the trustee will be informed in the offer document. My question to you is testing your company law knowledge. Under which form, okay, under which form is trust deed made? So obviously it will be in SH12 because that is same. So here they will say you have to make the enter the trust deed in SH12. It's given in your company law, and this point is also same, that the trustee shall not contain any provision which exempts the trustee from liability. The trust deed should not have any clause which states that if the trustee is negligent, they will still not be liable. We want the trustee to be liable. If the trustee should work for the benefit of the debenture holders. So this point again is very similar. It is same as what is given in your company law. So you can note it down. It will help you build your answer. Okay. Now, very, very important through the Amendment Act also. This is actually very important, that all debenture trust deeds must contain a provision mandating the issuer to appoint a person nominated by the trustee to be the nominee director of the issue, to be the nominee director of the company. Again, if there is a default, okay, then the debenture trustee will get a power. What power they will get is to appoint a nominee director. So imagine if the company defaulted in paying 2 consecutive interest we couldn't pay. So automatically the trustees will now say that on the board of directors we are appointing our director. So this clause has to mandatorily be there in the trustee, which gives the power to the trustee to appoint a nominee director. Clear? So note it down. Very, very important. It was through the Amendment Regulations 2023. Then again, you will have to comply with the listing agreement. Since obviously you are getting listed, they will have to comply with the listing agreement with their continuous listing requirement. It could be traded on the stock market. Now, new and important point and very nice point as well. What does it say? That the distribution of dividend in case of default can be blocked by the debenture trustee. Let's understand. Again, if there is a default in payment to the debenture holders, okay, there is a default, then the debenture trustee, who is here to protect the debenture holders, can block payment of dividend to equity shareholders. Common sense, we'll say, why are you giving dividend to the equity shareholders? I am blocking it. So the power will be given to the trustee to block dividends as well. They will say, first pay my money. Here you're making a default in payment to me, and there you're distributing dividend to everyone. Not allowed. Sorry. Then comes the obligation of the issuer. Let's understand what is the obligation of the issuer. Very simple, that the company which is raising the money, they will ensure that everything is done in a fair, transparent manner. They should not deploy any scheme, device, artifact to defraud anyone. They will give the facility to the investors of scores, which is your SEBI complaint redressal system, where if any investor is unhappy, they will go to the scores platform and complain against the company. So that can be done. Okay, and you have to ensure 100% security cover. So if the debentures are secured, they have to be secured by sufficient assets. Sufficient assets means if there is a default, they should be able to sell off the asset and recover the entire amount. Now, obligation of debenture trustee. Very simple. We know what is the obligation. They will work for the interest of the debenture holders. They have a right to appoint nominee directors. They will implement the entire scheme, and they will ensure that the security is enough to repay the entire debenture. So we are done with chapter number 2. That is your general conditions completely. You can take up points and you can build your answer if they ask you the general conditions. Now we'll be talking about public issue. Now we'll be talking about going to public. Now public issue of what? Of both. Whether you're making a public issue of debt securities or making a public issue of non-convertible redeemable preference shares. Let's see what are the points here. Now I want you to sit back and think. What all points will be there? I'm making a public issue. So obviously whenever I'm making a public issue, it is mandatory I have to appoint a merchant banker. That will be the very first step. Merchant banker. This merchant banker will be the lead manager. He will be he will take the lead. If there is more than one, they will have to identify who will be the main person who will be leading. Once it is there, you can issue green debt securities also. Now, once the merchant banker is appointed, he will say that, listen, where is the offer letter? What are you going to give it to the members? What are you going to give to the investors? So then no issuer shall make a public issue unless a draft document has been filed with the stock exchange. So a draft letter of offer will be given to the stock exchange first. The stock exchange will check it out and then only it will allow that the draft word will be removed and now a final can be issued to everyone. Okay. Then in the offer document, it will be mentioned that who is your company's, who is the compliance officer. And the compliance officer has to be a CS. And the compliance officer has to be a company secretary. Very, very important. Okay. Now, period of subscription. Again, it has been inserted via Amendment 2023. Now, what is the period of subscription that we are talking about? Everything has a time period. Any offer will have a time period. If we are offering our securities to the public, we expect them to subscribe within a certain time period. So what is the time period? So the time period is minimum 3 days and maximum 10 days. That is what the offer period has been given. 3 to 10 days the offer period will last. So the members can come and subscribe to the securities within this time frame. Now another thing is extremely important, very, very important. Why? Because you can quote it everywhere. What I'm going to tell you now, that every time there will be a offer document, right? Whether it is a private placement or private placement, but there would be some document or a public issue. There would be a offer document. The disclosure, what all disclosures are required. Okay. So here you will write it in almost every answer. The disclosures first, or the offer document shall contain all material, true, fair, adequate disclosures. Okay. And they should not omit any material statement. The offer document shall contain all the disclosures given under these regulations, all the disclosures required under Companies Act, and all the disclosures asked by SEBI. The lead manager shall exercise due diligence, proper due diligence, and the issuer shall ensure that the audited financial statements in the offer document shall not be more than 6 months old. This is also very, very important point. Let's understand. When the offer document will contain some financials, yes or no? Yes. These financials that we are referring to should not be 10 years old, 15 years. It should not be 6 months old. That means very new audited financial statements which we have received now, that only I can go ahead and mention about those facts. The lead manager shall ensure that all the disclosures are made are adequate and ensure that the track record of the public issues is disclosed. The track record of the public issues of the company is mentioned. Okay. Mode of disclosure. How will the disclosures be made? One is putting on the website of the stock exchange of the issuer and the lead manager. Advertisements will also be made now. The issuer will start doing ads. one of the ads is mandatory to be put up in the English paper as well as in a regional paper. The ad should not be misleading and it should be truthful, fair and clear, and should not contain any untrue or misleading statements. The advertisement that we put in the papers should not contain any matter which is extraneous of the contents of the offer document. That means whatever is mentioned in the offer document, some part of that only will be there. I cannot put anything new in the advertisement. Common sense. Credit rating which the company has received should also be prominently displayed. Then comes a topic called as minimum subscription. Very, very simple. Minimum subscription will be, normally we know it is 90%, that whatever is the issue size, if I'm issuing 100 crores, minimum 90 crores should be subscribed. So to ensure that that issue is not there, normally people keep underwriters. But minimum 90% is normally given. In these regulations, the minimum subscription is not 90%, it is 75% of the issue size. Okay, and in event of under subscription, then you will have to refund the entire amount. If everything goes well, then the allotment of securities can be done. If everything doesn't go well, then you have an underwriter, then the underwriter can underwrite the and subscribe as per the underwriting agreement. Then comes mandatory listing. Now, very simple. Let's understand this point. Mandatory listing of a public issue of debt and preference shares. Tell me one thing. If I'm making a public issue of debenture or preference shares, does it require mandatory listing? Does it require mandatory listing? Yes or no? I want an answer from you. Obviously you require. Why? How will the shareholders trade? How will they sell? Only if they get listed, then whoever have invested will buy and sell. So therefore, when I make a public issue and public have subscribed, then I have to apply for listing and list their securities so that it will be well traded. Okay. So an issuer desirous of making a public issue has to mandatorily apply for listing. If they fail to list, then they have to refund the entire amount. Then you have to give all the details for listing. Obligation of the lead manager, obviously the merchant banker will ensure that there is nothing done to to defraud the investors. He will see the security cover is proper, and he'll see all the interest payments are done on all the contents of the offer document are correct. Now some additional conditions they are giving with respect to debt securities. Very, very simple. This is some additional conditions with respect to debentures, non-convertible debentures. They talk about rollover of debentures. Now rollover means what? Extension of the time period. So if I have issued the debenture for 5 years and let's say at the end of the 5 years I say, listen, 5 years is there, just extend it for 1 more year. So that will be an extension called as rollover. Now what are the points of rollover? The issuer who wants to extend the tenure, roll over the debentures, they have to first give up a notice to all the debenture holders. Then it should be approved by majority of the debenture holders. A new credit rating should be taken and proper disclosures have to be given again. The trust deed, the security again has to be taken, trust deed. Existing trust deed may be continued. You have to ensure that the proper adequate security is there for the rolled over portion. And most important, what is the most important? That if there is someone who did not give his positive consent, did not agree to roll over, they said no, you said 5 years, now redeem me in 5 years. Then what do you have to do? You have to buy him out. For those who are agreeing, you can roll over. So these are the points of rollover. Due diligence of debenture trustees. that they have to do a proper diligence and say that yes, everything has been done as per law. Then again, very important point again, whenever we create these security, law says that you have to clearly mention that these securities are debentures. When you are saying secured debentures, what will you secure them by? Property, but property could be movable, immovable, tangible, intangible, or everything is allowed, right? It should be 100% security cover should be given. That is, if the debenture, secured debenture of 100 crores, property should also be of 100 crores or more. That is 100% security cover. Then comes chapter, so we've done with chapter number 3 also. Now we're seeing chapter number 4. Now chapter number 4, what does it talk about? Very simple. We did public issue. Now we are doing private placement. Okay. We did public issue. We saw all those merchant bankers and all of that is there. Right now we are doing private placement of what? Of debentures or preference shares. Okay, which are non-convertible. So what are the provisions? Very simple. What is a private placement? Let's understand that first. So private placement is issue of securities to certain identified persons, I identify that I have to issue it to him. It is not made, offer is not to all, offer is only to identified persons. Company knows in advance to whom they are issuing. Now these privately placed debentures or preference shares will also be listed. So they will also be listing. So again, the concept of listing will apply here also. Only thing is, the offer was not made to all, offer was made only to few, and then they gave the money and we listed their securities on stock market. That's it. So what are the provisions? Let's see. Since you're going to list them, you have to give an application. You have to give with all the documents, and in the documents you will give what was the offer price, what was the offer documents between you and that privately placed investor, placement memorandum, and all the basic details, MOA, AOA, last 3 years annual reports, all the necessary details will be given. The trustee, debenture trustee, will give a due diligence certificate to the stock exchange that all the laws have been completely followed. The stock exchange shall list the debenture securities only upon receipt of the debenture due diligence certificate. Market is important. So the stock exchange will first ask the debenture trustee that will ask the debenture trustee that is everything done properly. Yes, then list it. Disclosures again is very same. Disclosures, I told you, is very important, comes everywhere. Disclosures as given under these regulations, disclosures given under Companies Act, and disclosures given by SEBI. These disclosures will also be put up on the website. Okay. And then you can allot these securities and it will be issued to them in demat form. In demat form, you will credit the demat account of the investor. That's allotment of securities. Now, talking of additional provisions here also for debt securities issued on private placement basis. So you will issue a self-placement memorandum. Now market is important and pay attention to what I'm saying. When we make a private placement, don't you think we issue a offer document to them? Yes. That offer document here they are calling as placement memorandum. So placement memorandum will have to be given to them and that has to be filed with the stock market also. So that issuer making a private placement may file a shelf placement memorandum. Now understand what is a shelf placement memorandum. We've heard of shelf prospectus, right, in section 31 of Companies Act, that the company during the 1 year validity period they can come out with multiple issues. So shelf prospectus is a prospectus for multiple issues. Here what happens is we are telling that from the privately placed, I know this investor, in the entire year I will go 3 times to him. So shelf prospectus earlier was for the public at large. Here we are even making shelf prospectus for private placement, where I already identify that this person in a 1 year time span I will go to him multiple times. So I will file a shelf placement memorandum which will give me a validity of 1 year time period, and within that 1 year time period I can go for multiple issues to that investor. Okay, and every time I go to him I will have to inform the stock exchange that I went to him, and that will be called as a tranche placement memorandum. For that each tranche, for that each time I go to this within the validity period, I have to file a tranche placement memorandum. This is something new. Rest everything is same in your private placement also. Creation of security, create on movable, immovable, tangible, intangible, get 100% security cover. Now coming to, now we finished chapter number 4. Now we are doing about perpetual. Now we are doing about perpetual debt instruments. So perpetual is always under RBI guidelines, and RBI will notify how to go about. So it's a very small thing. It's unlikely that they ask in your exam because it's all RBI guideline based. So issuers are permitted by RBI to issue perpetual debt instruments, or perpetual preference shares can issue here. May list such instruments. They may issue such instruments in compliance with RBI orders. However, the disclosure requirements will be the same. Disclosures, they have, the issuer of these securities will have to make the necessary disclosures as specified under these regulations, as specified by RBI and Companies Act, and as specified by SEBI. Then coming to almost the last part, which is listing of commercial paper. So again, commercial paper, issuer can list commercial papers under chapter 6 of the NCS regulations. They will have to make an application, they have to make all the necessary disclosures, they will have to provide the scores facility for anyone who wants to complain as well. I told you commercial papers are short-term instruments issued by good credit rating companies to raise funds up to 1 year. Then coming to the 6th part, chapter 6, which is your online bond platform providers. So if you want to buy and sell bonds, there are certain platform providers. So these platform providers cannot act as and cannot do business unless they get without a certificate of registration by SEBI as a stockbroker. So this is the main regulation. Okay. So what is an online bond platform provider? Means a person who is providing buying and selling of bonds. Then comes the penal provisions, chapter number 7. If you have done violation, SEBI will first can do a suo moto inspection, or upon a complaint they can do an inspection. If SEBI finds something wrong, they can issue you directions, and if you have not followed the direction, then you can have penal provisions such as fines, imprisonments, etc. And that is it. We have completed the entire regulations. In the past exam, they had asked a question, wants to list his non-convertible redeemable preference shares on private placement basis. Okay, so you will write the chapter number. You will say that it's going to list it, right? So you will have to make an application to the stock exchange. You will have to make the necessary disclosures under these regulations, under the Companies Act, and as specified by SEBI. The dissemination of information will also be done on the stock markets, and audited financial statement shall not be more than 6 months old. And that is it. I have covered the entire regulations with all amendments in a short span. So this is applicable for your June 2023 attempt as well. Okay, so don't forget to share it with your friends and like the video as well. Thank you so much. And if you're new to the channel, subscribe And for CS professional students, we have a separate WhatsApp group. You can join our WhatsApp group as well. Thank you so much, Ashwarya. Take care, guys. Thanks. Bye.